under Article 257 of the Constitution, whether IEBC's administrative procedures are adequate to enable it to undertake its verification role, whether it had quorum to conduct business in that regard, and whether it is under a duty to conduct nationwide voter registration before carrying out the referendum. I'll also address under this theme the question of whether a single or multiple questions should be framed for the referendum. The fourth area is in relation to matters concerning the President. Does the President enjoy absolute immunity from civil proceedings under Article 143 of the Constitution? And was his right to fair hearing violated, and was he condemned and heard? And the fifth area I will touch on is on the amicus curiae, whether the High Court was wrong in admitting them in the proceedings. And sixth is the question whether the High Court wrongly exercised jurisdiction in the matter by reason of doctrines of mootness and ripeness, political questions and constitutional avoidance, and deference to other state organs. So I begin with the basic structure doctrine, and I reproduce there, and I will not read what the High Court said. I then look at the arguments from both sides, and then I say this. In terms of identification of the basic structure in the Constitution, the Court stated that it consists of the foundational structure of the Constitution as provided in the preamble, the 18 chapters and the 6 schedules of the Constitution, which form the fundamental core structure, values and principles of the Constitution, which cannot be amended without recalling primary constituent power of the people. This structure, the Court stated, outlines the system of government Kenyans chose, including the design of the judiciary, parliament, the executive, the independent commissions, and other offices, and the devolved system of government, and includes the provisions on land and environment, leadership and integrity, public finance, and national security. I then reproduce there at length what they say. To illustrate the distinction between unamendable and amendable constitutional provisions, the Court cited Article 2(1) of the Constitution, which provides that the Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government, as an example of an amendable or eternity clause, which can only be changed through exercise of primary constituent power on the ground that it expresses a core and fundamental principle of the Constitution. In contrast, the Court stated Article 2(5) of the Constitution, which provides that the general rules of international law shall form part of the law of Kenya, is also part of the basic structure, and that the spirit or the core meaning or value of that clause cannot be changed without involving the primary constituent power. It may, however, be amended through the secondary constituent power under Article 255 to clarify its meaning. The other example given is Article 89(1) of the Constitution, which provides that there shall be 290 constituencies, in respect of which the Court expressed that its core meaning and import can only be changed through primary constituent power, but the actual number of constituencies can be increased or reduced through either secondary constituent power or constituted power. I then set out the arguments that have been made on either side on applicability of the doctrine, and then I go on to say as follows. Having considered those arguments, the question whether the High Court correctly determined that the doctrine of basic structure is applicable in Kenya is a difficult one. The arguments advanced by learned counsel on both sides are powerful and most persuasive. The following, however, is the view I take. In his book, Constitutional and Administrative Law, Dimiss argues that although written constitutions differ widely in their purposes, form and content, they will normally be found to have two characteristics in common. Namely, there will be the fundamental law of the land, and there will be a kind of higher law and the legal source of legitimate authority. A higher kind of law in that the law set out in the Constitution will be hierarchically superior to other laws and will not be alterable except by a specially prescribed procedure for amendment. Chapter 16 of the Constitution, titled Amendment of this Constitution, prescribes the procedure for amendment of the Constitution. Article 255(1) stipulates that a proposed amendment to the Constitution shall be enacted in accordance with Article 256 or 257 and approved in accordance with Clause 2 by a referendum. If the amendment relates to the matters that are set out under that article, which I then reproduce. Article 256 sets out the amendment process through a parliamentary initiative, while 257 sets out the amendment process by popular initiative. On the face of it, those provisions of Chapter 16 of the Constitution would appear clear and unambiguous, and construed in their natural and ordinary sense would mean that every provision in the Constitution is amendable, provided the stipulated process of amendment is followed. However, Article 259 of the Constitution commands that the Constitution shall be interpreted in a manner that promotes its purposes, values, and principles, advances the rule of law and human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. Article 10 of the Constitution commands that in applying or interpreting the Constitution or any law, the national values and principles of governance set out in that article, including the rule of law, democracy, and participation of the people, bind all organs, state officers, and all persons. Earlier, the same principle of constitutional interpretation was expressed by the Court of Appeal in Tanzania in the Dianabo case, and I have reproduced portions of that. I have also cited the Supreme Court decision in the matter of interim independent commission, which expressed that rules of constitutional interpretation do not favor formalistic or positivist approaches, and that every style of constitution compels a broad and flexible approach to interpretation, and I reproduce segments of that judgment there. Given those principles of constitutional interpretation, the High Court was right in the methodology it employed in interpreting the constitutional provisions from a historical and contextual perspective, and the complaint that the court misapprehended the methodology applicable is not well-founded. What then is the doctrine of basic structure, and was the High Court right in holding that it applies in Kenya? In an article for the Center for Public Interest Uganda titled "The Basic Structure Doctrine and Constitutional Restraint, Take Away from Age Limit Decision," Benson Tusariwe writes that the doctrine of basic structure holds that the Constitution has certain basic features which underlie not just the letter, but also the spirit of that Constitution. These features constitute the inviolable core of the Constitution, and any amendment which purports to alter the Constitution in a manner that takes away that basic structure is void and of no effect. That even without explicit limitations to the constitutional amendment power, there are implied constitutional limitations to the nature and scope of constitutional amendments by which the Constitution should not be amended in a way that changes features of the Constitution that form its basic structure. The doctrine rests on the distinction between original or primary power to make or effect radical changes in the Constitution vis-a-vis secondary power to amend or effect minor changes on the Constitution. Under the doctrine, the decision to make fundamental changes to the Constitution is a matter solely reserved for the people, the Constituent Assembly. Courts may invalidate any exercise of the derivative amendment power that proposes to violate the Constitution's basic structure. Constitutional amendments may be found to be infirm because of the actual proposed content of the amendments that will replace the Constitution and not just amend it. Yaniv Rosnai, who was widely quoted by counsel in both sides in this case, states in his book, Constitutional Amendments, The Limit of Amendment Powers, that under the doctrine, the amendment power is not unlimited. Rather, it does not include the power to abrogate or change the identity of the Constitution or its basic features, and that any organ established within the constitutional scheme to amend the Constitution, however unlimited it may be in terms of explicit language, cannot modify the basic pillars underpinning its constitutional authority so as to change the Constitution's identity. The other phraseology used in reference to the doctrine of basic structure is quote-unquote unconstitutional constitutional amendments, UCA. In the article, democratic erosion, populist constitutionalism, and the unconstitutional constitutional amendments doctrine, Yaniv Rosnai again with Tamar Brandes argue, and I quote, one feature of modern constitutionalism that is especially relevant for constitutional change is that of constitutional unamendability. Constitutional unamendability refers to the limitations or restrictions imposed upon constitutional amendment powers from amending certain constitutional rules, values, or institutions, end of quote. They argue that unamendability may appear in the form of an explicit, unamendable constitutional provision, or may also be judicially imposed when the court derives such limitations implicitly from the Constitution, declaring that certain constitutional changes are strictly prohibited. They say that unamendability aims to protect the core values of the Constitution that express in a way its constitutional identity. And again, I have quoted from their work there at length. The doctrine therefore distinguishes amendment, properly so called, and dismemberment of the Constitution. Again, I cite a passage which I think has already been referred to by one of my colleagues from Richard Albert, Constitutional Amendments, that makes the point. As is evident from the material presented by both sides of the argument, the doctrine of basic structure is not new to our jurisprudence. It was acknowledged and applied by Rengera J in the case of Joya and others in the context of determining whether Parliament could enact a new constitution in exercise of its amendment power under Section 47 of the retired Constitution. Section 47 of the retired Constitution provided that subject to that section, Parliament may alter the Constitution. Justice Rengera found that Parliament had no power under the provisions of Section 47 of the Constitution to abrogate the Constitution and or enact a new one in its place. In reaching that conclusion, the judge found support in the dicta from the Supreme Court case of Kesavanda. And I have quoted that and also passages from Minerva Maize Limited. And then I have said as follows. In the end, Rengera J endorsed the view that every provision in the Constitution could be amended, provided in the result the basic foundations and structure of the Constitution remains the same. And there are other passages from that decision that have already been cited, and so I will skip them. There is also the decision of the High Court in the case of Commission for Implementation of the Constitution versus National Assembly, where Lenaola J, as he then was, expressed that the basic structure of the Constitution, which is commonly known as the architecture and design of the Constitution, ensures that the Constitution possesses an internal consistency deriving from certain unalterable constitutional values and principles, and that where the basic structure or the design and architecture of our Constitution is under threat, this court can genuinely intervene and protect the Constitution. In short, the doctrine of basic structure and the pillars on which it is founded has been recognized and applied by our courts and is very much part of our jurisprudence. It is not as alien a concept as perhaps some of the appellants argued in this case. In his book, Presidentialism in Commonwealth Africa, Professor Nabweze, in his discourse on abolition and attenuation of restrictions on the amendment power, discusses what he terms as the assault on the independence constitution of Kenya, which resulted in quote-unquote sweeping away of restrictions that had been entrenched with regard to alteration provisions. He states that the assault, culminating with what he refers to as the final stage, where an amendment could be made by a unicameral National Assembly with 65% majority, less than the usual 2/3. Against that backdrop, he argues, and I quote, "A constitution is supposed to be a permanent charter, which is to endure for all ages to come, not to be lightly altered to meet the temporary expediency of party politics. If the procedure for its amendment is not sufficiently rigid, and the temptation to alter it in accordance with the fancy or interest of the party in power is succumbed to over readily, the Constitution loses its sanctity in authority of the bedrock of constitutionalism and may become instead a mockery of the very idea of a government of laws. This is not to say that a constitution should be made unduly rigid, since that might invite its overthrow by revolutionary means when a genuine need for change has risen and cannot be effected constitutionally. He goes on to say that it may even be considered that the need for a constitution that is able to evolve with changing social and political conditions is perhaps greatest in a developing country. And then says that the really fundamental aspects of a constitution should be immune from alteration without reference. The really fundamental aspects of a constitution should be immune from alteration without reference to the people. He goes on to note, to give experiences, I think, from other jurisdictions in Africa, and I therefore then conclude that there is abundant authority, therefore, based on which the High Court concluded that the doctrine of basic structure applies in Kenya. What does all this mean in the context of the Constitution and the present appeals? It is perhaps in the manner of the application of that doctrine in the context of Chapter 16 of the Constitution where my perspective somewhat differs from that of the High Court. The journey of the Constitution of Kenya 2010 is well documented in the final report of CKRC as well as the final report of the Committee of Experts on Constitutional Review. The High Court, in this case, also gave that account. The Committee of Experts concluded in its report that, quote, the new Constitution of Kenya is a compromise and none of the interest groups, including the Constitution, the Committee of Experts itself, politicians and the religious sector, and the Kenyans at large got all that they wanted. But Kenyans must stand tall in the knowledge of having bestowed on themselves and future generations a constitution of their own and one that corresponds to their will and aspirations for a better, peaceful and prosperous future. And that what remains is to be vigilant in ensuring that the new constitution is implemented in the way in which it is designed to be. As I have already stated, the High Court in the present case found that in the making of the Constitution of Kenya 2010, Kenyans were insistent on the four sequential processes in the form of civic education, public participation and collation of views, constituent assembly debate, consultations, public discourse, and ultimately a referendum to ratify the Constitution. According to the High Court, Kenyans intended that the constitutional order they so painstakingly made would only be fundamentally altered or remade through a similarly informed and participatory process, and that it is clear that Kenyans intended that each of the four steps in the constitution making would be necessary before they denatured or replaced the social contract they bequeathed themselves in the form of Constitution of Kenya 2010. I understand the High Court to say that in making the Constitution of Kenya, Kenyans adopted a rigorous process involving the four stated steps to make it. To remake it or to fundamentally alter it, an equally rigorous process as was used in making it must be undertaken. In that finding, the High Court appreciated, correctly in my view, that a distinction must be made between amendment of the Constitution and abolition or annulment of the Constitution. For if what is proposed as an amendment is not in fact an amendment, then the provisions in the Constitution on amendment cannot be used to abrogate the Constitution. In his article, Constitutional Amendment and Dismemberment, Richard Albert argues, and I quote, the impetus behind the theory of constitutional dismemberment is that some constitutional amendments are not amendments at all. They are self-conscious efforts to repudiate the essential characteristics of the Constitution and to destroy its foundations. They dismantle the basic structure of the Constitution while at the same time building a new foundation rooted in principles contrary to the old. These constitutional changes entail substantial consequences for the whole of law and society. End of quote. Abolishing or abrogating provisions of the Constitution in such a way as to alter its foundation and structure is therefore not envisaged under Chapter 16 of the Constitution. That is a preserve of the people exercising sovereign power which belongs to them in accordance with Article 1 of the Constitution. To that extent, I am in agreement with the High Court. As I have stated, it is in the manner of the application of that doctrine, given the text of Chapter 16, where I take a different path. According to the High Court, the identification of whether a provision of Constitution is part of the basic structure is a matter of analysis on a case-to-case basis. In the words of the High Court, quote, whether a particular clause in the Constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution, its foundational structure, its text, its internal coherence, and the history of the clause, and the constitutional history, and other non-legal considerations permitted by our canon of constitutional interpretation principles, end of quote. On my part, I am persuaded that the framers of the Constitution identified for all to know what the basic structure of our Constitution is. In what learned counsel referred to as the hierarchy of norms, the framers set out in Article 255(1) of the Constitution what they identified to be the fundamental pillars that define the Constitution. Those provisions are amendable in the sense in which I have referred to that word as meaning minor revision, addition, or modification in contradistinction to dismemberment in accordance with Article 257. Provided the amendments proposed do not amount to an abrogation or dismemberment of the Constitution, they are permissible. But even then, such amendment not amounting to dismemberment of the matter set out in Article 255(1) of the Constitution must be done in accordance with Article 257. In other words, the doctrine of basic structure, as I understand it, is a complete bar to dismemberment or abolition of provisions of the Constitution in the name of amendment. Abolishing or abrogating those provisions cannot be an amendment within the purview of Chapter 16 of the Constitution. On the other hand, under the Constitution, all provisions of the Constitution are amendable in the sense of correcting, modifying, clarifying, improving, or expounding without fundamentally altering the identity of the Constitution. The matrix, as I see it, is that if a proposed change to the Constitution is a dismemberment of the Constitution, then Chapter 16 provisions are not available. If, on the other hand, the proposed change is an amendment, properly so called, then the next question is whether it relates to a matter set out in Article 255(1) of the Constitution. If so, then the provisions of 257 must be invoked. If it does not touch on any matter set out in 255(1), then the amendment may be pursued via the parliamentary initiative route under 256. Ultimately, however, whether a particular proposed amendment is strictly that or a disguised attempt to abrogate the Constitution is a matter for judicial interpretation. Based on the foregoing, my conclusion in relation to the basic structure doctrine is that it is applicable in Kenya. In its application in the context of our Constitution, it bars the dismemberment, replacement, or abolition of the Constitution in the name of amendment. The Constitution does not envisage, contemplate, or permit its replacement, abrogation, or its dismemberment. That is a preserve of the people and can only be done by the people outside the framework of the Constitution, following the procedure used or akin to that used to make the Constitution, and which must include civic education, public participation, collation of views, constituent assembly debate, and ultimately a referendum. The doctrine does not, in my view, prevent genuine amendments to the Constitution. The framers of the Constitution identified the matter set out in Article 255(1) of the Constitution as the core or the basic structure of the Constitution, and any amendments properly so called to the Constitution relating to or touching on those matters can be done in accordance with Article 257, infused with the national values and principles. Whether a proposed amendment amounts to a dismemberment, abolition, or derogation of the Constitution is, as I have stated, ultimately a matter of judicial interpretation. Any other amendment to the Constitution that does not relate or touch to those matters can be made in accordance with 256. In my view, there are no eternity clauses in the Constitution. I then look at the scope of popular initiative and public participation, and I conclude as follows. Having considered the rival arguments on the remit of popular initiative and popular participation, the issues arising are whether an amendment of the Constitution by popular initiative is a preserve of the citizen, whether the President or the Executive can initiate amendments through the popular initiative, who was the promoter in this case, what is the scope of public participation in that regard. And I set out the provisions of Article 257, which I will not read. And I then say that on the face of those provisions, there is no qualification of who may or may not promote a popular initiative. As correctly submitted by counsel for the appellants, there is no explicit bar against any person, including the President, from promoting a constitutional amendment by popular initiative. It is not, as it were, in the black letter of Chapter 16 of the Constitution who may or may not propose an amendment. It is a matter of interpretation in accordance with the principles of constitutional interpretation to which reference has already been made. And then I go on and say, in the end, the framers of the Constitution separated the route which the elected representatives can take for amending the Constitution through parliamentary initiative under Article 256, and the route which the citizen can take through popular initiative under 257. Although the phrase popular initiative is not defined in the Constitution, the background I have set out above and the lexical meaning of the word popular lend credence to the conclusion reached by the High Court that the amendment by popular initiative under Article 257 is the preserve of the citizen. The concise Oxford English Dictionary, for example, the word popular is defined as including intended for or suited to the taste or means of the general public. Merriam-Webster Dictionary also defines the word popular to mean of or relating to the general public. In both definitions, the phrase general public features, and I do not think the President or the Executive would fall under the category of general public. In reaching this conclusion, I am cognizant of the provisions of Articles 19, 20, 22, 24, and 38 of the Constitution, and the contention that the holder of the office of the President, like every citizen, is entitled to enjoy rights under the Bill of Rights. However, it seems to me that the curtailment in certain respects of those rights in relation to the holder of the office of the President is sanctioned by the Constitution, given the constitutional role assigned to the holder of that office in the process. As to who the promoters with respect to the Constitution Amendment Bill is concerned, I will just summarize that and say, I take the view that the process began with a handshake, followed by the establishment by the President of the task force. Thereafter, the President established the BBI Steering Committee, whose mandate included proposing constitutional reforms. The BBI Steering Committee generated the Constitution Amendment Bill. The President and Honorable Raila Odinga then flagged off the signature collection. The Constitution Amendment Bill and the list of voters supporting was then delivered to IEBC by Honorable Mohammed and Honorable Aweru, the co-chairs of BBI National Secretariat. And I then say it is a continuous process, it is a continuum. It is unnecessary, in my view, to attempt to split that process to justify the claim that the process towards initiating the popular initiative began with the delivery of the draft amendment bill and supporting signatures to IBC, and to ignore what preceded that. The delivery of the draft bill and supporting signatures to IBC was part of a process that had begun before the generation of the draft amendment bill by the steering committee. In my view, all the players in that process, beginning with the President, Honorable Raila Odinga, the BBI steering committee, Honorable Mohammed, Honorable Aweru, qualify as promoters in a continuum that preceded the delivery of the bill. I do not think there is merit in the contention that the President's involvement in the amendment process was in his capacity as a private citizen. The material presented shows otherwise. The Kenya Gazette notices based on which the task force and steering committee, whose mandate, as I have mentioned, included consideration of proposals for amendment of the Constitution, are testament that the President was acting in an official capacity. And then regarding public participation, I have made reference to the guidelines that were given by the Supreme Court of Kenya in the British American tobacco case, and I have set those out. And then I have said that there can be no question, therefore, that public participation is a fundamental constitutional principle in our country, a major pillar and bedrock of our democracy and good governance, to quote the words of retired Chief Justice Mutunga in the matter of the National Land Commission. It is a constitutional command that it must be infused or integrated into the amendment process under Chapter 16. And then I set out other arguments, and then I conclude that I am therefore in agreement with the High Court that there is a legal requirement under Article 10 of the Constitution for voters to be supplied with adequate information to make informed decisions. There is no evidence that that was done in this case. I would not go as far as the High Court did in prescribing in minute detail how public participation might be undertaken. As the Supreme Court stated in British American tobacco case, allegation of lack of public participation must be considered within the peculiar circumstances of each case, and the mode, degree, scope, and extent of public participation is to be determined on a case-to-case basis. It is perhaps also a matter for the legislature to prescribe in appropriate legislation the scope and breadth of public participation, short of which the court is left to apply the standard of reasonableness on a case-to-case basis. To be clear, I take the view that amendment, properly so called, of matters touching or relating to Article 255 is achievable through what the High Court referred to as secondary constituent power, namely public participation and referendum. And then I deal briefly with the issue of verification. And then I say as follows. Having considered the arguments, I take the following view. The role of IEBC upon delivery of the draft bill proposing amendment to the Constitution by popular initiative is set out in Article 257(4). In an affidavit sworn on 25th of February 2021, Michael Goa, a Director of Legal and Public Affairs of IEBC, deposed that IEBC received the draft amendment bill on 10th December 2010, accompanied by 4.4 million supporters' signatures, upon which it issued a press release on 18th December informing the public of the same. That IEBC carried out a process to confirm that the said initiative was supported by the signatures of at least 1 million registered voters in order to ensure compliance with the requirements of Article 257. That after completion of that process, an interim report was prepared during which data cleaning exercise by removing incomplete records, including missing signatures, ID numbers, names, duplicates, and those not in register. And that a list of verified supporters was uploaded on IEBC's website to enable them to check and confirm their details. That the purpose of uploading the list of verified supporters on the website was to provide an opportunity for objection by anyone who had been captured as a supporter without their consent. That upon completion of that process, it was established that the popular initiative met the constitutional threshold, and the amendment bill was transmitted to the county assemblies. Based on the depositions in that affidavit, the finding by the High Court that the role of IEBC under Article 257(4) entails ascertaining the number of registered voters in support of a popular initiative to amend the Constitution and verifying that the initiative is indeed supported by the registered voters claimed to be in support is correct. As submitted by Council, the verification of signatures of supporters of the Constitutional Amendment initiatives entailed ascertainment of whether they were registered voters and had appended their signatures. The controversy appears to be with regard to precisely how IEBC was to execute or carry out the verification. According to IEBC, that would be achieved by posting the list of voters claimed to have supported the initiative on its website for scrutiny, with an invitation that any objections should be raised within a given period. The respondents, on the other hand, argue that IEBC should itself have undertaken a forensic examination. In the case of National Super Alliance versus IEBC, the court stated that courts cannot step in to police or prefect independent constitutional bodies or direct them how to carry out their own mandates, unless there is willful neglect or violation of their constitutional or statutory functions. And the independent commissions are clothed with discretion and latitude to decide the governance process or the procedure to employ as to how and when to execute their mandate, as long as it is within the law, and that this operational and functional independence has constitutional underpinning. So guided, the question is whether IEBC properly discharged its verification mandate under Article 257(4). The record shows that IEBC uploaded the list of signatories in support of the initiative on its website on 21st of January 2021. The closing date for scrutiny and for any objections to be taken was indicated to be Monday, 25th January. Under item Q and R of Part B on verification procedure of IEBC's administrative procedures, it states that after actual signature verification exercise and documentation, the compiled list of supporters is published in the Commission's website for information and verification for 2 weeks. Publishing the list of supporters over a weekend was clearly in violation of IEBC's own prescribed time frame of 2 weeks. The time provided for scrutiny and for raising objections was grossly insufficient. Why IEBC was in such a rush is not clear. Secondly, there is the question whether merely uploading the list on IEBC's website without more is sufficient. Would it have been more effective for IEBC to, in addition to uploading the list on its website, to publicize the matter in other media as well? These questions are germane and bolster the argument that a comprehensive legal or regulatory framework for the conduct of referendum is important. In my view, had the IEBC given sufficient notice, opportunity, and means to the public to interrogate the list of verified supporters of the initiative, it would perhaps have been considered to have been discharged its duty of ascertaining and verifying that the registered voters who had indicated as supporting had indeed done so. That said, the conclusion by the High Court that IEBC's role under 254 involved both ascertainment of numbers of registered voters in support of a popular initiative to amend the Constitution, as well as verification of the authenticity of those signatures, is partially correct in my view. Yes, IEBC is required to ascertain that the threshold of 1 million registered voters is met. Secondly, it must verify or establish or confirm that those voters whose names that have been submitted have in fact endorsed the initiative. That, as I have stated, is in my view achievable if IEBC affords reasonable means and opportunity for the voters to interrogate and confirm their endorsement of that initiative. That said, this discussion is further testimony of the need for legislative and regulatory framework for matters relating to Article 257. I then move on to look at the regulatory and legal framework, and I think I'll just go to the conclusion. And I say this: there is undoubtedly, therefore, some legal framework, albeit not an elaborate one, for the conduct of referendum, even though it may not specifically address or fully address all aspects of a referendum, including matters of collection, presentation, and verification under Article 257 of the Constitution. I do not doubt, as I have mentioned, that it is important to have specifically tailored legislation that specifically and fully addresses matters relating to Article 257. Indeed, there is realization in that regard, as it was demonstrated that there are 2 pending bills before the National Assembly in that regard. That said, I agree with the High Court that notwithstanding the absence of an enabling legislation as regards the conduct of a referendum, such constitutional process may still be undertaken as long as the constitutional expectations, values, and principles and objects are met, and that in doing so, the process must be in strict compliance with inter alia Article 10 of the Constitution, which prescribes the national values and principles. and that those principles must be infused at every stage of the process. That statement is consistent with the legal principle exemplified by a decision of this court in IEBC versus National Super Alliance, where this court reversed a finding by the High Court invalidating procurement of ballot papers without legislative framework to facilitate a meaningful program of public participation. In doing so, this court expressed, and I quote, "The absence of a legal framework for public participation is not an excuse for a procuring entity or a state organ to fail to undertake public participation if required by the Constitution or law. A state organ or procuring entity is expected to give effect to constitutional principles relating to public participation in a manner that satisfies the values and principles of the Constitution." End of quote. Equally, the absence of a legal framework per se cannot be a basis for asserting that IEBC should not discharge its constitutional mandate under Article 257. There is also the High Court decision in Titus Alila, where the question whether there was a proper legislative framework for holding a referendum arose, and the High Court found that the Constitution has already set up a proper legislative framework. In my view, therefore, the declaration by the High Court that the absence of a legislation or legal framework to govern the collection, presentation, and verification of signatures and other conduct of referenda renders the attempt to amend the Constitution through the Constitution of Kenya Amendment Bill flawed, even though qualified with a statement in the circumstances of this case, is one I am respectively unable to endorse. To the extent I construe it to mean that IEBC cannot, absent specific legislation on conduct of referenda, conduct referendum under Article 257. There is then the matter of IEBC's administrative procedures. And on that, I capture the arguments and then say that whereas the administrative practices were not avowedly made in exercise of the Commission's power under Section 31 of the Act, in a replying affidavit sworn by Michael Goa of IEBC, he deposed that the administrative procedures were developed pursuant to Section 55 and Regulation 98 of the Election General Regulations 2012 after extensive public participation. Accordingly, based on Michael Goa's deposition, the administrative procedures fall within the statutory definition as they are made or established in execution of a power conferred by or under an act of Parliament, under which that statutory instrument or subsidiary legislation is expressly authorized. Moreover, this court can only interfere with the decision of the High Court if it is established that the High Court misdirected itself in law and that the decision is plainly wrong. On the matter of quorum, I say this. My view is as follows. Section 5.1 of the Independent Electoral and Boundaries Commission provides that the Commission shall consist of a chairperson and 6 other members, appointed in accordance with Article 254 of the Constitution and the provisions of the IEBC Act. Section 5.3 provides that the process of replacement of a chairperson or member of the Commission shall commence at least 6 months before the lapse of the term of the chairperson or member of the Commission. Section 5.4 provides that the procedure set out in the first schedule shall apply with necessary modifications whenever there is a vacancy in the Commission. Section 7A of the IEBC Act provides that the office of the chairperson or a member of the Commission shall become vacant if the holder dies, resigns from office, or is removed under circumstances specified in Article 251 and Chapter 6 of the Constitution. Under Section 7A(2) of the IEBC Act, the President is required to publish a notice of vacancy in the Gazette within 7 days of the occurrence of such vacancy, and the process of recruitment, quote, shall commence immediately after the declaration of the vacancy by the President, end of quote. Section 8 of the Act provides that the conduct and regulation of the business and affairs of the Commission shall be as provided for in the second schedule, but subject thereto, the Commission may regulate its own procedure. Paragraph 5 to 7 of the second schedule, prior to amendments introduced through the Election Laws Amendment Act number 34 of 2017, provided, and I have reproduced those provisions there, I will not read them, and then I say that through Election Laws Amendment Act 34, paragraphs 5 and 7 of the second schedule are repealed and replaced with those provisions. Paragraph 8, which was not affected, of the second schedule, provided that subject to paragraph 5, no proceedings of the commission shall be invalid by reason only of a vacancy among the members thereof. Those amendments were successfully challenged and declared unconstitutional by the High Court in Katiba Institute case, and I have cited passages from the judgment of Justice Muita, which are there. IBC contends that as paragraphs 5 and 7 as previously enacted had been repealed, the declaration by the High Court invalidating the amendments did not revive the repealed provisions. It was urged that by relying on provisions of paragraphs 5 and 7 of the second schedule as they existed prior to the amending provisions being declared unconstitutional, the court relied on non-existent provisions, and therefore Article 250, which sets the minimum at 3, applied. Respectfully, I do not understand the decision of the Supreme Court in the case of Mary Wambui, which was cited as supporting the proposition put forth by IBC. If I understand the argument correctly, it is that the effect of the declaration of unconstitutionality by the High Court of the provisions of the Election Laws Amendment Act number 34 that had sought to amend paragraphs 5 and 7 of the schedule is that the schedule is now silent on quorum. That there is in effect no longer a provision at all in the schedule on quorum, and therefore recourse must be had to Article 250. I am not entirely persuaded by that argument. Article 250 of the Constitution does not, with respect, address the question of quorum of the Commission. It is a provision on composition. It sets the minimum number of persons who must make up the Commission. Quorum speaks to the minimum number of commissioners that must be present to make a binding decision. It speaks to the number of commissioners who, when duly assembled, are legally competent to transact the business of the Commission. As defined in Black's Law Dictionary, it is the minimum number of members who must be present for a deliberative assembly to legally transact business. Article 250 of the Constitution cannot therefore fill the gap which the IBC says was created by the declaration of unconstitutionality of the provisions that had sought to amend paragraphs 5 and 7 of the second schedule. In the case of Mary Wambui, the Supreme Court in paragraph 87 of the judgment expressed as follows: however, while we have pronounced ourselves on the issue of invalidity of section 76(1) of the Elections Act, in line with the Constitution, this court is not precluded from considering the application of the principles of retroactivity or proactivity on a case-to-case basis. I then look at the decisions they cited there, including the decision by Justice Kriegler in the South African case of Sias Moyes, and I then go on to say that the decision of the High Court in the case of Katiba Institute was silent on the effective date of the declaration of unconstitutionality. Based on the decision of the Supreme Court, I take the view that the default position is that the declaration of unconstitutionality related back to when the unconstitutional provisions were enacted, with the result, in my respective view, that the status quo ante was restored. Therefore, the requirement of quorum of 5 applies. I am therefore in agreement with the High Court that when it pronounced in the judgment that IBC Act categorically places the quorum of IBC for purposes of transacting business at 5 commissioners, and that IBC did not have that quorum at the time it made the consequential decision related to the Constitution of Kenya Amendment Bill. IBC also contended that the impugned decision of the High Court runs afoul of a subsisting decision in rem in a constitutional matter in the case of Isaiah Biwott, which has been extensively cited. And I'll cut through and just say I am conscious that this court is not presently sitting on appeal from the judgment of Isaiah Biwott, However, it seems to me that quite apart from reading into the text of paragraph 5 of the schedule, the words policy decisions, and apart from mixing up composition with quorum, the learned judge appears to have either overlooked or infused statutory provisions with what she considered to be common sense when she stated, quote, "My take is that the issue of quorum, apart from being a matter provided for under the statute, is also a matter of common sense and construction, depending on the total number of commissioners." And then I have the rest of the passage, and then I say, further, in making that pronouncement, the learned judge does not appear to have considered the provisions of paragraph 8 of the second schedule, which provides, subject to paragraph 5, no proceedings of the commission shall be invalid by reason only of a vacancy among the members thereof. Under that provision, the requirement under paragraph 5 is overriding. The pronouncement by the judge in the above cited passage appears, therefore, to be an abrogation of a statutory provision, and to that extent is per incuriam. Consequently, the High Court in the present case was entitled, for that reason, among other reasons the court gave, to depart from it. Moreover, the statutory commands in the IBC Act, if heeded and complied with, would have ensured that the number of commissioners would not have fallen below the number required to form a quorum. For those reasons, the complaint regarding the findings by the High Court as to quorum have no merit. I then move on to the issue of continuous voter registration, and I think I'll just say what I concluded. The High Court cannot therefore be faulted for having concluded, as it did, that there was no evidence that IEBC had discharged its obligation of continuous voter registration. I would therefore not interfere with the decision of the High Court. The last aspect I think I'll look at, separate and distinct referendum questions. On that I say, in my reading of those provisions, that is of the Constitution, it is the bill in which an amendment proposal is contained that is submitted to the people to vote on in the referendum by indicating whether they agree or disagree with the amendment proposal, much in the same way as the members of the county assemblies and members of the Houses of Parliament would have signified their approval or disapproval of the amendment process in the draft bill. It seems to me, therefore, that under Article 257(10) of the Constitution, as read with other provisions in that article, what is envisaged of the voter at the referendum is for the voter to make a choice to ratify or not to ratify, to approve or not to approve the amendment proposal in the draft bill. However, that choice, in my view, is rendered nugatory, inoperative, and consequential if the voter is called upon to vote on an omnibus draft bill that contains a raft of numerous, diverse, and unrelated proposed amendments to the Constitution, in this case over 70 proposals, that cut across the entire spectrum of the Constitution. And I cite the passage there from the High Court decision entitled Alila. The argument made for the respondents on the principle of unity of content or single subject matter, that constitutional amendment through a referendum should deal only with one main issue, is one I find most attractive and persuasive. It was argued that under that principle, the proposed amendment should deal with one subject only to allow the voter to form and express their opinion freely and genuinely. In other words, if a proposed constitutional amendment includes several substantive questions, the voter may not have a free choice, that each proposed constitutional amendment ought to secure adoption on its own merits, not on the merits of other different proposals to which it is attached, and that there must be an intrinsic connection between the various parts of each question to put to the vote in order to guarantee freedom of suffrage, and the voter must not be expected to accept or reject as a whole provisions without an intrinsic link between them. I would venture to suggest that what is envisaged under Article 257 is an amendment bill on single thematic topic to which the provisions in the draft bill must relate. For instance, a bill proposing amendments to the provisions on land under Part 1 of the Chapter 5 of the Constitution would, in my view, be incongruous with proposals in the same bill for amendment of the and related matters of the Office of Parliament under Part 3 of Chapter 8 of the Constitution. Ultimately, it seems to me that to put a single binary question or multiple questions is a matter to be informed by the nature of the amendment proposed. It may well be that certain proposed amendments may require separate and distinct referendum questions to be framed. What, in my view, Article 257(10) of the Constitution does not contemplate is the submission to the people in a referendum of an omnibus amendment bill, a hodgepodge of an amendment bill such as the Constitution Amendment Bill in this case. The argument that it would be impractical on account of logistical difficulties to formulate over 70 separate and distinct questions is perhaps more the reason that an omnibus amendment bill should never be entertained. Then I move on to constituency apportionment, and I think I have agreed with the lead judgment of the President, and so I will not deal with that. And then I deal with the matters touching on the President. Under this head, the issues are whether the President's right to fair hearing was violated, whether the President enjoys absolute immunity under the Constitution, whether the High Court was right in declaring that the occupier of the office of the President is liable to being sued in his personal capacity during his tenure of office. And I think I'll just go to the conclusions, which are as follows. Article 51 of the Constitution provides that every person has the right to have any dispute that can be resolved by application of law, decided in a fair and public hearing before a court, or if appropriate, another independent and impartial tribunal. Therein is the long-standing principle of natural justice that traces back to Ridge versus Baldwin, and also the case of Onyango, Olo Onyango versus Attorney General. I have also cited it there. The critical question, which is a matter of fact, is whether the President was firstly served with a petition 426 in which he was named as the first respondent, and secondly, whether he was served with notice of hearing. The record of proceedings of 21st of January 2021 show that the High Court gave directions on the conduct of the consolidated petitions. Among the directions given on 21st were directions that, quote, all the petitioners in the 7 petitions to serve the petitions on all the parties by close of business on 22nd of January 2021. The Deputy Registrar to facilitate the process where necessary, and that the respondents, interested parties and amici to file and serve their responses to the various petitions within 14 days. On the same date, directions were given by the court regarding exchange of written submissions and the conduct of the hearing and hearing dates. The record shows that on subsequent appearances before the High Court, under the quorum in relation to petition 426 of 2020, the court always indicated no appearance for first respondent. The record does not show whether after the directions given on 22nd January 2021, any inquiry or follow-up was made by the court to confirm that his directions regarding service had been complied with. In subsequent attendances before the High Court, the record continued to reflect that there was no appearance for the first respondent, that is the President, in petition 426. The petitioner in 426, Isaac Alwocher, indicated on the face of the petition that it was to be served at the office of the President, Harambee House, Harambee Avenue, Nairobi. An email address was given and telephone numbers and a Twitter handle. Before this court, Mr. Alwocher filed a supplementary affidavit dated 8th June 2021 in which he attached an affidavit of service sworn on 16th of January 2021 in which he stated that he served the petition by email on all the parties, including the President, whom he served at the stated email address on 21st of December. He stated further that he also lodged a service request with the judiciary e-filing platform and got a response on 15th January, and that all parties had been served. Notwithstanding the directions given by the High Court on 21st of January, to which I have referred, it appears to me that the question whether the President was in fact served with a petition and the hearing notice in respect of the hearing appears to have been overlooked by the High Court. The continued indication in the record, no appearance for first respondent against the name of the President, after the directions given on 21st of January, should respectfully have signaled the court to inquire whether the president had in fact been served. The depositions by Mr. Alwocher in his affidavit sworn on 16th January 2021, filed in hearing, are matters that should have been presented before the High Court in order to satisfy itself that the president was duly served. In paragraph 537 of the judgment, the High Court observes that the President did not enter appearance in these proceedings, and neither did he file any grounds of objection or replying affidavit to contest these proceedings on the ground of misjoinder or any other ground. However, there is no indication that the High Court satisfied itself that service had been effected in the first place. Indeed, in the same paragraph of the High Court judgment, the court stated, quote, "As much as the Honorable Attorney General has come to his defense, the grounds of objection and submissions filed by the Honorable Attorney General are clearly stated to have been filed on behalf of the Attorney General himself and not for Mr. Uhuru Muigai Kenyatta," end of quote. An acknowledgement, in my view, that the proceedings against the President were undefended. Having concluded that the Attorney General could not in this instance represent the President, it was imperative for the court to satisfy itself that the President had been served with the petition and the hearing notice. It is also noteworthy that although the High Court expressed in paragraph 532 of its judgment that the question whether the President can be sued in his personal capacity and not as the President of the Republic is a question that, quote, should be determined as a preliminary issue, quote, it was not in fact handled in that manner. For had it been handled in such manner, the determination should have been made before the substantive hearing of the petition commenced to afford the President an opportunity to defend himself in his personal capacity. By making the determination in the final judgment, that opportunity was lost. All in all, I am not persuaded that it was satisfactorily demonstrated that service on the President was effected, and for that reason alone, I would set aside the orders made by the High Court against the President in Petition 426 of 2020. On the presidential immunity question, I have indicated that I sat in the judgment of this court in Kenya Human Rights Commission and another versus Attorney General, and my views have not changed that the decision of the High Court is right in that regard. I still hold, therefore, and agree with the pronouncement by the High Court in the present case that the President can be sued in his personal capacity during his tenure because the protection afforded under Article 143(3) of the Constitution extends, quote, anything done or not done in the exercise of his power under the Constitution. On the issue of the amicus curiae, I have referred to the Supreme Court decision of Trusted Society of Human Rights and the extensive guidelines that were given there, and I have concluded that it was not demonstrated that the High Court exercised its discretion wrongly in admitting the amici. On the issue of justiciability, I have said that the matter was ripe and that it was not prudent for anybody to wait until the provisions became the Constitution and then have to contend with Article 2(3) of the Constitution, which prohibits any challenges to the Constitution. So with that, I will end it there and hand it over back to the President. Thank you.
Thank you very much, Brother Justice Gatembe. It is now 1:40. We shall adjourn for one.